Greetings and welcome to this video on the Fourth Amendment and how to analyze a Fourth Amendment problem. Oftentimes, both law enforcement and attorneys who work in the criminal court system must confront questions about whether the Fourth Amendment has been violated or not. And over the last 100 years, this has become incredibly complicated. It's become even more complicated in the last few years as we begin dealing with technological change. And so the purpose of this video is to simply provide you with an overview of how to think about a Fourth Amendment problem. Whenever we look at the Fourth Amendment, we have to think about the text first, so we will look at that. And the text is going to then raise three key questions that you need to answer. Of course, with each of those questions, there are sub-questions that must also be addressed and must also be answered. And depending on how we answer those questions is going to determine whether or not the Fourth Amendment has been violated. And so we will walk through each of those major questions along the way, look at what those potential answers may be, and then figure out what the sub-questions are and how answering those sub-questions connect back to our major questions. By the end, we should be able to have a short hypothetical and apply these questions to it to determine an outcome. So let's start with the Fourth Amendment itself. It says this: the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. And so with this, we have three key questions that we have to answer. And they are dictated by the two clauses in the Fourth Amendment. The first clause talks about unreasonable searches and seizures. The Fourth Amendment only applies to searches that are unreasonable. And so we have to figure out two key things from that. And those are going to be our first two questions. Number one is there a search? Was there a search conducted by or requested by law enforcement? If the answer to that question is no, then the Fourth Amendment doesn't apply and the search is okay, we can proceed. So an example of that may be someone who is choking, they are brought into an emergency room, the emergency room physician conducts a search to figure out what the person is choking on, and during that search, the surgeon finds a bag of drugs. That would not be a search that's covered by the Fourth Amendment because it was not done by law enforcement and it was not done at the request of law enforcement. However, if the answer is yes, that law enforcement did conduct some sort of search or they requested some sort of search, then we have to figure out what exactly is a search. And there are lots of different tests that we can use and sub-questions we have to ask in order to determine if a search has occurred. The first is simply whether there was a trespass on property or not. If law enforcement has gone on to private property to look for something, then we have a search. If it is someplace that is open to the public, someplace where the public can go, then law enforcement can go there as well, and we have no search. And so if the answer is yes, there is a trespass on property, then we must go to the second question. But if the answer to that question is no, that we don't have a trespass on private property, we have to go to the next sub-question. And the next sub-question is, does the defendant, the person who is on trial, does that person have a reasonable expectation of privacy in the place that was searched or in the item that was seized? That in and of itself, to determine the answers to that question, we have to ask some sub-questions. The first is the expectation of privacy objectively reasonable? If the answer to that question is no, then we don't have a reasonable expectation of privacy. But if the answer to that question is yes, then we have to go on to another sub-question. However, to determine if we have an objective reasonable expectation of privacy, we have to ask a few other questions. The first is the item that was seized in plain view? If it was in plain view where anyone could see it, then the person does not have a reasonable expectation of privacy in that particular item, and it can be seized. There is no search. Next, was that item exposed to a third party? So for example, if we were talking about telephone records, who have you called in the last month? Your phone company keeps track of those records. Therefore, that's been exposed to a third party. In addition, the person you called knows that you have called them. These are records that are generally available. Therefore, you have no reasonable expectation of privacy in those records. We call this the third party doctrine. Again, if I am putting out a message or a sign on my front yard, I don't have an expectation of privacy in that. It's been exposed to a third party. Finally, even if we haven't placed the item in plain view, even if it hasn't been exposed to a third party, does society recognize this particular interest as private? If so, then again, you're going to have an objectively reasonable expectation of privacy. So if the answer to either of those first two questions, was the item in plain view, was this exposed to the third party? If the answer to those questions was yes, then you do not have an expectation of privacy that would lead to a search under the Fourth Amendment. However, if your answer to those questions is yes, and society does recognize this as reasonable, then we have to figure out, is our expectation of privacy subjectively reasonable? That basically means, did the person take some sort of steps to demonstrate that the person actually believed there was an expectation of privacy in the item seized or the place searched? In order to have a reasonable expectation of privacy, you must give yes answers to both an objectively reasonable expectation of privacy and a subjective reasonable expectation of privacy. If you don't have yes to both, you do not have a reasonable expectation of privacy. So, to sort of track back, if we don't have a trespass, if we don't have a reasonable expectation of privacy, now we have to sort of ask a third question. And that is, does the actions the police took, does it yield so much information about the person that we are nevertheless going to consider it a search? There are lots and lots of open questions about this, questions we don't know the answer to in terms of how much is too much, over what period of time, does it matter if it came from multiple sources or not? None of these questions have been answered. This is sort of a new direction that the U.S. Supreme Court is going in the area of the Fourth Amendment, but it's a question we need to be aware of and attempt to answer nonetheless. Finally, even if we have a trespass or a reasonable expectation of privacy, we may have to ask whether the search was, or the action was something less than a search, but it was justified on the grounds of reasonable suspicion and did not go any further than a pat down for weapons to make sure that the officer is safe. If that is done, then we're not going to really call that a search under the Fourth Amendment context. So that wraps up the first question of the Fourth Amendment. Do we have a search that was requested or conducted by law enforcement? If there's no trespass, if there's no reasonable expectation of privacy, if it didn't yield so much information that we're going to call it a search, then there is no search. However, if there is a trespass, if there is a reasonable expectation of privacy, or if it did collect so much information that we consider it a search, then we have to go on to the second question. With a search, is that search reasonable? This is where the second clause of the Fourth Amendment comes in. The second clause of the Fourth Amendment is the warrant clause. It talks about warrants have to be issued on the basis of probable cause by oath or affirmation and be specific about what is searched and what is to be seized. Therefore, we have to ask what makes a search reasonable. Simply having a search warrant makes it reasonable. If you don't have a search warrant, we're going to say that it is per se unreasonable. And so that's our first sub-question. Did we conduct this action on the basis of a valid search warrant? So how do we know if we have a valid search warrant? First off, is there probable cause? To determine if we have probable cause, that's going to mean answering certain other questions. First, is there sufficient evidence to believe a crime has been committed? We have to produce in our affidavit some evidence that a reasonable person would believe warrants further investigation that a crime yet has in fact occurred. We also have to ask, is there sufficient evidence to believe that additional evidence of that crime is going to be located at the place to be searched? Right? We have to be able to say, yes, we have reason to believe that the evidence is located at this particular place. Finally, if we are gathering our information about the crime or about evidence at the location through an informant, we have to make sure that that informant is either one, credible, or two, that we corroborate what that informant is saying. Or three, you can bring the informant in and have the informant swear to the information. Any three of those things would work. You just have to make sure you have one of those three things. If you don't have one of those three things, then you may not have probable cause, and therefore you may not have a valid search warrant. In addition to probable cause, the warrant must specifically provide a place to be searched. It has to be specifically identified. If it is not sufficiently identified, you do not have a valid warrant. We know it's sufficiently identified when a reasonable person who is looking at the warrant can tell where to search and where not to search. Finally, as our third question under if we have a valid search warrant is, do we specifically detail what it is to be seized? We must specify what evidence we are looking for that will contribute to proving a particular crime occurred. And again, we use that same standard. As an outside person who is looking at the search warrant, would they know what is to be seized and what is not to be seized? If you can make that distinction, then you have sufficient specificity for your warrant. If you have probable cause, if you have specific place, specific things to be seized, then you have a valid search warrant. However, there are circumstances where we may have a warrant that has been signed by a judge. The judge says it is sufficient. However, upon review, another court says no, this was not a sufficient search warrant. So in other words, we have a facially valid warrant, but when it's reviewed, it is determined to be invalid. In those instances, the search will still be reasonable. The officers who conducted the search acted in good faith, and so as long as we have the good faith, we are okay. The search is reasonable. A third scenario is that we could have a search but not have a warrant. Remember, we said that is per se unreasonable, but we may still have a proper search. The way we determine that is whether we have a valid exception to the warrant requirement. And over the last 100 years, courts have carved out various exceptions to the warrant requirement. One of the first exceptions that we may want to think about is whether there was probable cause to search a vehicle. This is the original exception to the warrant requirement. Vehicles, whether it's a car, whether it's a boat, whether it's a plane, are easily movable. They can go from one place to another, and so if the officer conducting the search has probable cause, as we just outlined, then the officer can search that vehicle, because to do otherwise would allow the suspect to get away with the evidence or destroy evidence because it is easily movable. So if you have a search with probable cause of a vehicle, you do not need a warrant. Second potential exception is exigent circumstances. Right? Is there some sort of emergency or immediate need to search the location? So for example, you may be investigating a shooting. There is a case where someone shot a gun up through the ceiling of an apartment into the apartment above the where the gunshot took place. The officers had exigent circumstances to go into that above apartment and search and look for victims. So those would be exigent circumstances. A third potential exception that you need to think about is whether the search occurred incident to a valid arrest. So if you arrest somebody as law enforcement, you may search that person. You may also search anywhere that is in the immediate control or reach of that person. The idea is to search for evidence that can be destroyed or weapons that may be used against the officer. You cannot go beyond that person's immediate reach. You also cannot search vehicles incident to arrest. You can only search in the area where the person would have access. A fourth exception is what we call an inventory search. So did the police search the vehicle or someplace pursuant to valid inventory procedures? If that occurred, then you can search without a warrant. And finally, searches at the border, the United States border, can be conducted without having to get a warrant. And we need to think about the border broadly. The border is just not the geographic borders of the country. They are ports of entry, so therefore international airports, even if it is in the middle of the country, if it is a place where people are entering the country, that is a border for the purpose of border searches. It can also be any place where packages are coming in and out of the United States. And so you may have Federal Express facility in Indianapolis, right? Nowhere near a U.S. border, but that is a border for the purpose of border searches. And so if you have a border search, you can also have a search without a search warrant. And so that brings us to the end of our second question, right? Is the search reasonable that we have conducted? Do we have a valid search warrant? If yes, it's a valid search. It's a reasonable search. Do we have a facially valid warrant that's later declared invalid by a court? If the answer to that is yes, then we have a valid search or a reasonable search. Or do we conduct a search without a warrant, and does it fall under one of the typical exceptions to the requirement? If the answer is yes, then we have a reasonable search. So as long as the search is reasonable, then we can stop our inquiry there. However, if the answer to that is no, we don't have a search warrant, we don't have a facially valid warrant that's later found to be invalid, and we don't have a recognized exception, we need to ask our third question. The third question is, assuming the search was not reasonable, is there a reason not to exclude the evidence? And for violations of the Fourth Amendment, courts have said that evidence must be excluded from the court. It cannot be used against a defendant. The main rationale for that remains is that we want to deter the police from violating people's Fourth Amendment rights. So therefore, we have to ask, do the circumstances of the search that was declared unreasonable, would they have an effect of deterring the police? If the answer to that is no, it's not going to serve as a deterrent, then we may not need to exclude the evidence. And there are three different ways that we can think about that. The first is, would discovery of the evidence have been inevitable during the course of the investigation, without violating the Fourth Amendment. So, for example, did the police do something unconstitutionally? But then, if they hadn't done that, they would have acted constitutionally in another manner and found the evidence. So let's assume that the police searched a car incident to arrest, and they did so improperly. Ordinarily, that evidence then would be excluded. However, if we add in the fact that the car is parked illegally and needs to be towed, we can say the police would have conducted an inventory search and therefore would have found the evidence inevitably through a constitutional means. If that is the case, then we are not going to exclude the evidence. Similarly, the second one is independent discovery. Would an independent means of investigation have led us to the evidence through a constitutional means? In other words, even if we did violate the Fourth Amendment, we had this independent line of investigation that was going on, it would have led us to the evidence. As a result, we are going to allow that to be admitted into evidence as well. Finally, courts have recently added a third exception to this, and that is whether the police are relying on good faith interpretations of the Fourth Amendment that have since been overruled. So let's go back to our search incident to arrest of a car. At one point, police acting on Supreme Court decisions said that searching a car incident to arrest was permissible. Later on, the Supreme Court changed that and said, no, you can't search a car incident to arrest. But what about all those cases that were pending prior to that Supreme Court decision? Can they still use that evidence? And the answer to that question, according to the U.S. Supreme Court, is yes. So if you're relying on a clear interpretation of Supreme Court precedent and that interpretation changes, or that precedent changes, then the evidence will not be excluded. So that takes us through the Fourth Amendment analysis. We have to ask three basic questions. Was there a search conducted or requested by law enforcement? If the answer to that question is yes, we have to go on to the second. Assuming we have a search, is the search reasonable? If the answer to that is yes, then we are done. If the answer to that is no, we go on to the third question. Assuming the search was not reasonable, is there a reason not to exclude the evidence? As you work through each of those questions and each of those sub-questions, you should be able to identify the different issues and problems that arise in the Fourth Amendment context and be able to analyze a full set of facts. What might that look like? Let's say you are a police officer, you pull over a car. Right? You walk up to the car. You look inside and you see several bags of cocaine in the back seat. Do we have a search? Well, you're in a public place, you're in a spot that is publicly permissible, you look into the window that is exposed to a third party, you see the bag of cocaine, it is sitting there, you don't have a search. You're able to recover that cocaine, it's not a search, end of question. Now, let's add something to it. You've walked up to this car, the person rolls down the window, and you smell marijuana, but you don't see any marijuana. So now, with that smell, you have probable cause to believe there is a controlled substance in the vehicle. So we look at our first question. Are you going to go look for that substance? Well, you are trespassing on property. If you go into that car, it's that individual's private car. Also, they have a reasonable expectation of privacy in their car. It is objectively reasonable. Society recognizes that value of privacy, and if it's not sitting out somewhere open, then the driver has taken some sort of steps to conceal the marijuana, and as a result has demonstrated a subjective expectation of privacy. So now you have both. We have a search. Now, so we go on to question 2. Do we have a warrant? No, we don't have a warrant. So nor do we have a facially valid one that is later going to be determined to be invalid. So now we have to go down to can we search without a warrant? Do we have an exception? The answer to that is yes. We have probable cause to search a vehicle based on the smell. Notice how we walk through each question along the way. And that's how we look at a Fourth Amendment problem. Again, as the facts increase, as they become more convoluted, more complicated, the questions become more challenging, and you have to spend some time addressing them. But make sure you address all of those questions in turn as you approach these particular problems. I hope this was helpful. Feel free to let me know if you have any comments, questions, concerns, or criticism.